the name of Almighty Allah, the most merciful. In our today's session, we have brought a topic under this playlist of legal review, and this topic is relevant to the law students and to the legal fraternity and the students studying in different universities. I'm delighted that I'm joined with two very promising law students, including Ms. Afsha Sarfaraz and Ms. Aisha Zafar. You both are most welcome on the session.
Thank you,
Thank
sir.
you so much, sir.
You're most welcome. So let's begin our session. First of all, there is a synopsis prepared for the topic. So let me request Ms. Afsha to read this synopsis.
Synopsis. Through the constitutional petition, the petitioners have sought cancellation and declaration qua the impugnant notification dated 26 January 2021, through which petitioners are awarded major penalties, permanent expulsion, and rusticated from academic degree programs of University of Veterinary and Animal Sciences. The petitioners sought that the impugnant notification may graciously be set aside, quashed, and declared to be null and void for being illegal, unwarranted, unjust, violative of the Constitution of the Islamic Republic of Pakistan 1973 policy on protection against sexual harassment. In Higher Education Institution 2020 and Discipline and Conduct Regulations 2003,
Thank you very
keyword
much.
present, the area within
Thank you very much, Ms. Afsha, for your participation. In this synopsis, Ms. Afsha has shared with us that basically this is a constitutional writ which is filed under Article 199 of the Constitution. And in this writ, it is sought that the impugned notification through which the petitioners are, there is an order for expulsion of the petitioners, and some of the petitioners are rusticated for 2 years or 1 year period from their academic degree program. And basically, there is a law involved beside the constitutional framework. There are relevant laws. One is the Harassment Policy of Higher Education Commission 2020, and then there is a Discipline in Conduct Regulations 2003 of University of Veterinary and Animal Sciences. Like all universities in our country, they have their own discipline and conduct regulations, and under these regulations, they regulate the functions of the students studying in the university. And at the same time, these regulations are also relevant to the faculty members. So everybody is there to be regulated. Likewise, we have studied in corporate governance regulations that corporate governance regulations are meant for companies enlisted in Pakistan Stock Exchange. So in order to regulate the functions of the relevant subjects, there are regulations made by the authority. In this case, University of Veterinary and Animal Sciences, they have made their regulations, and on the basis of those regulations, they have awarded penalties to the students. Now we have the second, in fact, part, and in which I have, in fact, prepared the list of keywords which are used in this legal review for the law students. And the very first word used in these regulations and policy is precinct. And beside this word, I have taken down the transcription of this word. Transcription is basically the received pronunciation, the standard accent, which is used in British English. So the word is precinct, and that means the area within the walls or perceived boundaries of a particular building or place. So in this case, we will study a regulation which used the word precinct. So any action, any omission which is committed in the university precincts within the four walls come under the ambit of this law. The second word is expulsion. The transcription of this word expulsion is given underneath, and expulsion means the act or forcing out someone or something, and the synonyms, as you know, are ejection and exclusion. And next keyword is, and there is an example given, the child's expulsion from school. In this case, we have veterinary doctors who are expelled from the university. Rusticate is the next word. As rusticate means to suspend somebody temporarily from college or university. Rag is the word actually. So the allegation on the petitioner was that they were involved in ragging of their junior students. So ragging is defined a practical joke, especially by college students, cause annoyance in, disturb, especially by minor irritations. And the word, in fact, coined from rag is ragging, the act of one who rags or teases. So these are the key words actually used in this discussion. Excuse me. Now the important facts. Ms. Aisha Zafar, please share with us. Perhaps there is some link issue. Uh, Ms. Afshan, could you please read? Yes, Ms. Aisha, you are there. So please read important facts.
Yes, sir. On the basis of his academic achievements, one of the petitioner has earned an excellent CGPA, that is 3.76, in his preceding semesters and maintained his academic excellence since the very inception of this ongoing degree program. That
Yes, due to this alleged complaint. Yes, please, Ms. Aisha.
due to this alleged complaint, petitioner were barred to attend their classes. Resultantly, they were unable to take their midterm exams.
Right. Please continue.
The complainant submitted a handwritten presentation titled "Withdrawal of Inquiry" on 13/11/2020 prior to the decisions. Through this representation, the complainant sought the withdrawal of his complaint.
Thank you very much, Ms. Aisha. And then comes another fact, which is at number 4. Ms. Afshan, please share with us.
Yes, sir. That against the impugned notification dated 26th January 2021, petitioners filed a review before the Vice Chancellor of the University within limitation as provided under enabling regulations. The relevant provision, Sub-Regulation 1 of Regulation 20 of Discipline and Conduct Regulations 2003, is reproduced for kind pursuant.
Yes, please continue, Ms. Afshan.
Yes, sir. The punished students may apply for review of the order passed on his her appeal to the Vice Chancellor within a period of 15 days from the announcement of the orders of the Appellant Authority Dean's Committee. The said review is pending, wherein no date of hearing is fixed as yet. That the alleged ragging incident took place on 25th October 2020, admittedly at a private flat situated outside the university precincts. That the alleged act does not fall within the mischief of enabling provisions, regulations, and does not constitute indiscipline and misconduct. That the petitioner's track record is clean. They were never involved in any sort of misconduct in the past. In spite of all this, they are awarded with the major penalties.
That's right. Thank you very much, Ms. Afshan. The keywords actually I have shared has the relevance with the relevant provisions of law. As you found that the word precinct, for instance, since this alleged ragging took place at a private flat, which is not within the four wall of the university, So we won't say that this is within the precinct of the university, or this is within the four walls of the university. And furthermore, now we will look at the relevant law, and we will find that what are the provisions which are applicable, or in the impugned notification dated 26 January 2021, the Dean's Committee actually has applied the law, which itself says that if the alleged occurrence has taken place at the precinct of the university, since admittedly this incident did not take place at the in the precincts of the university, this is at a private flat, so we cannot say that the law is relevant. If I quote an example here for the law students and for the litigant public or university students, let's say that in the classroom or within the university, you are not allowed to smoke. But if you start smoking outside the university, then the regulation of university will not applicable upon you. Of course, I mean, being a parent, everybody will ask you to refrain from smoking. But the point is that the regulations are applicable on a certain area. So if you are beyond that area, regulation will not be applicable upon you. So that is the important thing. And if I quote, if I broaden this example, you know that there are certain acts which are known as legal acts in certain countries. For example, drinking is not prohibited in United Kingdom, but it is strictly prohibited in Pakistan. So the point is that the law is applicable within the area, within the precincts. So in this case, if regulations are applicable on university precincts and students have committed it, then this law is applicable upon them. But on the other hand, in this case, these veterinary doctors, they did not commit any offense or any ragging at the university campus. So let's have a look at the relevant regulations. Ms. Aisha, please.
Regulation A, that bear reading of enabling provisions of the policy in vogue, that is, Policy on Protection Against Sexual Harassment in Higher Education Institutions 2020, clearly envisage that the alleged act of ragging do not fall within the mischief of the relevant provisions. 3.1 Regulation A. This policy applies to actions by students, faculty, staff, other members of the HEI community, such as interns, residents, etc., or third parties such as service providers, visitors, etc., when the misconduct occurs. B. Of the HEI property. If the conduct occurs in connection with an HEI recognized program or activity, or the conduct may create a hostile environment or pose a safety risk on campus.
Thank you very much. Now, this is important to look at this. And this clearly provides that if the occurrence has taken place at higher education institution property, HEI stands for higher educational institution. So of the HEI property, but then that incident has to be, has to be taken place at at an activity which was recognized by the university. If I quote an example, if veterinary university will send its veterinary doctors, uh, to uh, to a livestock farm situated in Renala Khurd or Kadrabad, where we have buffalo and cows, livestock, you see, farming. And now university has planned that these certain number of students will go and inspect on ground at Kadrabad livestock and dairy development site, and they will conduct certain experiments. During this recognized program or activity, if any student driving Lahore to Kadrabad Sahiwal, if he commits some act or while reaching at Kadrabad, if that student has committed some act which is within the purview of these regulations, we can say that he has committed an offense or he has committed something which needs to be penalized. So if it is off the HEI property, then that activity has to be a recognized activity. Now, in this incident, in this case, these petitioners were penalized that they committed ragging at a private flat away from the university. So, how come this law is applicable upon them? So that was the question we have brought to the court in constitutional jurisdiction. And when you get to know the decision of the court, you would be delighted that the Honorable Court has recognized this very aspect, that you cannot apply the law because this act, alleged act, is not committed in at the precincts of the university. So let's move on. The second actually part of this regulation, that is the conduct may create a hostile environment or pose a safety risk on campus. So it clearly, I have underlined for you that this clearly reflects that that must be on campus. Now, admittedly, this incident has taken place at a private flat, not on campus. So we cannot say that this law is applicable on the petitioners. Now, let's have a look at the other part of this law, and that is the relevant law, that is Discipline and Conduct Regulations 2003. Ms. Afsha, please.
Yes, sir. That Discipline and Conduct Regulations 2003 promulgated by the university clearly envisioned that the alleged act of ragging does not fall within the purview of the provisions of regulations as made applicable on the petitioners in the impugned notification. The following, among other violation of the provision of the Code of Conduct, shall constitute acts of indiscipline and misconduct for which action may appropriate penalties on the defaulter. Breach of rules of public morals, such as use of indecent or filthy language in classrooms, residential halls, playgrounds, and on the campus. Use of immodest, improper, and provocative dress. Use of undesirable remarks or gestures.
Right. Now, here we can see, I have underlined that this activity, ragging, for instance, or use of indecent or filthy language, that has to take place at the classrooms or residential halls of the university or playgrounds of the university and on the campus. Now, admittedly, this ragging has taken place at a private flat outside the university campus. So we cannot say that the students have committed any offense as far as the enabling provisions of law are concerned. Now let's have a look at the next part of this regulation. Ms. Aisha, please.
Disorderly behavior such as shouting, abusing, quarreling, fighting, and insolence, use or attempt or threat to use force, defiance of authority, impersonation, perjury, giving false information, willful suppression of information, cheating, deceiving, and stealing, shouting of slogans derogatory to the prestige of the university or the reputations of its teachers and officers, keeping of licensed or unlicensed arms, or entering the university with arms. Every member of the teaching staff shall have the powers, and it shall be his/her duty to check disorderly or improper conduct or any breach of the rules by students occurring in any part of the precinct of the university.
Absolutely. Now look at this underlined word, precinct. As I said earlier, precinct means within the four walls. So, as I said earlier, that these regulations or the policy envisaged by the Higher Education Commission directly deals with the occurrence taken place at the precincts of the university. Since this is outside the university premises, our case is that this does not fall within the mischief of Conduct and Discipline Regulations 2003, and this does not fall in the purview of Higher Education Commission policy 2020. So let's have a look at further aspects of this case. Now, there is another provision of law which deals with this case law. So let's have a look, and let me ask Ms. Afshan to share with us.
Yes, sir. That according to Section 24A of the General Clauses Act 1897, public functionaries are duty bound to decide every matter pending before them without fear, favor, with reasons, and within a reasonable period of time. The Section 24A of General Clauses Act 1897 is reproduced.
Please pause here
24A
for a
exercise.
minute, Ms.
Yeah.
Afshan.
Yes,
Now
sir.
look at these keywords, that within a reasonable period of time. Moreover, without any fear or favor, with reasoning, that order has to be a speaking order. So the petitioner went to the court of law that their review is pending before the vice chancellor. Already the dean's committee has awarded the punishment, and now in the review which is pending before the vice chancellor, the honorable court may kindly direct that the vice chancellor should decide the matter in accordance with law. So the legal provisions are brought before the court for the assistance of the court, and you have seen Section 24A of General Clauses Act that is brought in the petition that was presented to the court, and then the constitutional provisions which are relevant actually, especially Article 4, Article 5, and Article 9 of the Constitution, which deals with this scenario, is in fact discussed, is relied upon. And the reliance was not only on the constitutional provision of Constitution of Pakistan, but the reliance was also placed on judicial precedents, and especially the judgment rendered by Honorable Supreme Court of Pakistan that was reported in 1998 in Supreme Court Monthly Review at page 2268 was referred. I'd like you, Ms. Aisha, to share this judicial precedent with us.
Judicial precedents. The Honorable Supreme Court of Pakistan, in its authoritative judgment cited as 1998 SCMR 2268, the ratio decidendi of above referred judgment is reproduced here and below. The doctrine has further been recognized and augmented by the recent insertion of Section 24A in the General Clauses Act 1897, which declares that where a statute confers a power to make any order or to give any direction to any authority, office, or person, such would be exercised reasonably, fairly, justly, and for the advancement of the purpose of the enactment. What is more, the order or direction, so far as necessary or appropriate, would reflect reasons for its making or issuance, and where the same is lacking, an effectee may demand the necessary or appropriate would reflect reasons, which, in response, would be furnished.
Absolutely right. So the sightline D of this judgment, and the relevant page is 2277, which deals with this aspect. And the Honorable Supreme Court of Pakistan has said that the decisions are required to be made as per law. And as we discussed, that the law, the policy of Higher Education Commission and university regulations, I mean, the act which is committed does not fall within the mischief of that. So we, the petitioners, were of the view that the decision is harsh, the decision is unjust, and that has to be set aside. And then we have referred on number of other judgments also rendered by the Honorable Supreme Court and Honorable High Courts. And finally, the decision actually, which is given by the Court of Law, the Honorable High Court has issued writ of mandamus. And in this writ, actually, the Honorable Court directed the Vice Chancellor to decide the pending review within a period of 2 weeks from the date of receipt of this certified copy of the order. So as a matter of fact, the court has directed the Vice Chancellor to decide the pending review, and that decision is required to be made in accordance with law. So this was the whole discussion on this legal review. And I thank you, Ms. Aisha Zafar and Ms. Afsha Sarfaraz for your active participation, and looking forward to see you in our next session. Thank you very much.